We start and do my best to continue letting everybody in while I'm also giving a brief introduction.
Multitasking.
Yes, doing my best. Thank you all for joining us this morning. You know, HR law continues to change. We thought we might get a break after everything settled down after COVID, but that just doesn't appear to be the case. So we're really grateful to have Michael Santo back with us today. Auto Paychecks has made it a priority to educate and bring relevant and accurate information to business owners in the community. We really thank you for continuing to trust us and our resources and the partners that we're able to bring forward. If you don't know me, my name is Manon Jacob. I hope you might recognize me by now. If you have questions or follow-up, please go ahead and reach out to me. My email address is m.jacob@autopaychecks.com. We're going to be hearing from Michael Santo today. You probably all recognize him by this point. He's done a lot of work in the community to really help continue to provide education and has been gracious enough to partner with us through several webinars. Today is more of an employer advisory. I know Michael does plan to spend a significant amount of time talking about family. And there's a lot of questions that we've had from our clients, and we hope that some of them will be addressed today, and we'll all continue to learn as things continue to change. A little bit of housekeeping. We ask that all attendees please stay muted so that we can have a clear audio and recording, but we do really encourage questions. If you've ever been to a seminar or presentation by Michael before, it does a really great job of answering questions as they're coming in. So please open up your chat function and make sure you type in those questions as you have them, and I'll do my best to make sure we address them. Again, this is going to be recorded, and the slides along with the recording are going to be sent out later this afternoon. So if you're registered, we have your email address and we'll be sending that out to you. You can also view this later at the autopaychecks.com blog. All of Michael's previous webinars that he's done with us are also on there, so if you ever need to refer back to...
Although I've never watched one. I refuse.
I have seen a couple of mine, and it's always painful to watch yourself. So Michael is the co-founder and partner of Bechtel & Santo, which is the labor law attorney office here downtown. His information is up on the screen, so if you need to reach out to him directly, you certainly can. He publishes a quarterly newsletter that you can sign up for. If you haven't already, I would suggest that you do so. It's a great way to stay current with the important information like this, and we will send a link out to that newsletter so you can register if you are not already. So Michael is our local labor law attorney and guru. He is a frequent lecturer on employment law issues and a contributing author for several publications like the Practitioner's Guide to Colorado Employment Law and Practitioner's Guide to Colorado Business Organizations, just to name a few. Michael has practiced most of his law career in Colorado, and for the majority of his career, he's focused on defending companies in employment litigation, counseling companies on day-to-day employment. This includes advising employers on hiring, discipline, and termination decisions, on leave and disability issues, and on preparing and revising employee handbooks. He's an incredible resource. If you need advice, please reach out to him. He really has a very impressive resume, and we highly recommend him to all of our clients, and you will have his contact information. So I'm going to get out of the way because really we're here to learn from Michael.
Thank you for that introduction. I was just, as you were talking about what we're going to talk about today, I remembered back to when we decided to do a little update. We had picked the date in mid-November because the thought was that the big change that was going to occur was that the federal government was going to make a very large announcement with respect to the salary basis test. For those of you who have been keeping track of this, to be an exempt employee, to not get overtime, to not have to worry about keeping track of time, you have to meet two tests, you as the organization. One is that they perform certain duties, and two is that they get paid a certain salary. In Colorado, we have that set, and ours is a little higher than federal law. The reason why Manny and I picked this is because a couple of months ago, the federal government dropped hints that in October, they were going to make a rather large change to the salary basis test. Currently for federal law, it's about 35. Colorado, it's 45 or 50, depending on what year we're in. So if you hear this in 2023, it may have already flipped. And so there are those that have opined that the federal government is going to move that salary basis test from the current 35 threshold way past Colorado's threshold, maybe up to in the 60s or even the 70,000 range. So we said, let's put together a talk because it'll be a great time to go over all the really big changes that the federal government's going to have with respect to the wage issues. And then, well, apparently they got busy with the elections or whatever's going on, and they didn't make any announcement as to that. And fortunately, though, as Manning identified, it right now is never a dull moment in employment law. We're going to be going over a bunch of issues today. I'm going to bet most people have questions with respect to the first. So if we spend more time on that, that's just the way it goes. The materials are all there available. So don't hesitate to ask questions. And Manning does a great job of feeding me them. And there we go. We were just having clicker problems earlier. Okay, what's the first thing we're going to talk about? It's the four-letter word on everyone's mind, family. It's not technically 4 letters, but just work with, yeah, no, it's over. It's the 5-letter word on everyone's mind, the family program. As we all know, we've got, what are we down to, man? In 6 weeks until family goes live. And it's currently going live-ish. One of my main recommendations with respect to everyone, and I mean everyone, even if you're exempted, even if you've opted out, make sure you sign up on the department's website. They were doing soft launches in the last couple of weeks. They're now fully in. You have got to get signed up by January 1st, 2023. I saw Tracy Marshall, who's the head of the family, just a few weeks ago, and we were talking about that, and she said, well, it's not definitely January 1st, and I said, it's definitely. Let's give everybody a very defined date, and so I've been encouraging January 1st. Let's go through some things. What is family? Family is a leave program that we all voted in, so apparently we all did, because 58% of us voted for this, that will provide employees anywhere from 12 weeks of paid leave to 16 for difficult pregnancies, for any of these conditions. So these are just the basics. The leave doesn't start though until 2024. So you got time to figure out the leave. The thing you need to figure out more quickly, for those of you who are government on the line, you need to figure out if you're going to opt in, opt out. Hopefully you've already made that determination, had a vote with your board, but that certainly needs to be determined before too long. For private employers, I'm going to go over all this, it's the 2023 is the year of the reduction for the premium. Don't call it a tax, because it's not a tax. A tax would be illegal, and it couldn't possibly be a tax. It has to definitely be a premium. What are the premiums currently set at? Well, right now they are set at 0.9% of the employee's wage. You as the employer, if you're covered, have to pay for 0.45%, and the employee has to pay for 0.45%. If you want, you can pick up the employee's share, not required to, but you can. The reasons we have on the screen up there are the reasons for the leave. Just blanking again. There we go. What's our timeline? And when I'm standing up, I actually walk through this, but obviously I'm sitting down for this talk. this is our timeline. And as you see, we're getting really close to that top line, which is in family premiums and remitting payments start. The first payment needs to be sent on April 30th, 2023, although there's going to be a 30-day grace period of the premiums you collect from the employees over the first 4 months. And then you will send in, much the way you do unemployment, you'll send in those premiums to the state. You're already turning to me like, I have a question.
I have a question, just because you mentioned the government opt-out earlier. So we have a question that says, we are a government and have opted out, but will withhold for those employees who elect family. Can government employees wait to opt, I think they meant out, participation and pay premiums until 2024?
Yeah, it's an interesting question. I had this question come up, in fact, spoke with Ms. Marshall on it, because there seems to be kind of a loophole in the rules that it's not one they like to normally talk about. I normally don't bring up but there is an issue with organizations, government who opt out and then may opt in at the end of 2023 and various different things. And so that is a small little issue with employees opting in 2023 or not opting, 2022, then the organization opts in 2023, thereby saving the employee a year of premiums. That is one of those, it's a very odd issue for just public employers, so I don't want to go too far down that rabbit hole, but that is out there.
And then we had a question specifically for auto paychecks, and did we enroll our clients into FAMLI? We did have access to early enrollment as a third-party reporter, so unless you've told us that you wanted us to not register for you, so you opted out of registration, then yes, we are registering you for FAMLI.
And I know you guys have a talk on Friday with the CDLE, and I think the specific purpose is going to be walking through how to register.
Yes.
So something for those of you who have got registration questions, make sure you're looking at the talk. Auto Paycheck does a phenomenal job of making sure resources and talks are available. So yes. Your question?
Nope.
Okay. Participation is basically going to be required for all employers, as Matt and I were just saying. You have to register and create an account. They say April 30th. I would just do it before the end of the year. Please, please, please. Before the end of the year. Avoid the Christmas rush. Get it done soon, and it's all taken care of. You don't even have to worry about it. That's why I say here, the FAMLI Plus Employer has begun. You'll start having access in January 2023, and that's when the premium deductions will begin from employees if you're going to hold back the 0.45%. You're going to then, as this goes along, you're going to do your quarterly wage reports along with the 0.9% premium payments to the family division. Again, works just like unemployment at the beginning of this process.
We do have questions.
I'm ready.
Okay. So if my small business under 10 employees chooses not to pay the employer share of the premium, does the employee share stay at 0.45 or does it move to 0.9?
It stays at that's a great question. If you are under 10 employees, as you see in this chart right here, perfect lead-in from that person, only the employee premium is required. The employer premium is not required. I had someone ask me, well, we're thinking of doing the employer premium just to kind of help everyone else so premiums don't rise. And I was like, well, that is very nice of you. But you may want to curry some favor with your employees by maybe paying their 0.45 if you're going to, because I don't think one employer's contribution is necessarily going to save the rest of our premiums from going up anywhere, although I did appreciate that employer worrying about that. But this is the premium responsibilities. You can see those who are not participating, there are no premium, and then we got the 10 or more employees. You're good. Do you have a question?
No. I was thinking you got hung up again, and I don't know.
Yeah, one of the odd things about FAMLI, not odd is the best way to say it, but one of the interesting things about FAMLI is it has repeatedly kind of said, we're going to fall back on federal law, we're going to fall back on the FMLA when there's something available. Okay, that makes sense. federal law on the FMLA, Family Medical Leave Act, for those of you with 50 or more employees. You've been working with this since 1993. That law defines how we determine if there are 50 or more employees. And as we identified here, the total of the employees on the payroll during each of 20 or more calendar work weeks. The interesting thing, though, about FAMLI, Colorado FAMLI, is we're only going to do it once a year. For those of you who have been working with the federal FMLA, it's more of an ongoing thingy. It's a constant redetermination of how many people do I have on the payroll, how many people don't I have on the payroll. But as this slide identifies, counting employees under FAMLI will only be a once a year thing. So keep it in the first quarter of the year. So keep track of that for small employers. Anyone who's on your payroll is counted, part-time, full-time, regular, seasonal. You know, you got those employees who, Bob's been on workers' comp for 100 years. He's still on our payroll. He still counts. So make sure you're counting all the correct number. Really, the only big count, the two questions, I don't know if I actually have it in here, man, now that I think about it, because I didn't want to spend too much time on FAMLI, but is the count for employees. We get this question all the time. I got 6 employees in Colorado, and I got 6 employees in Utah. Am I covered by FAMLI? Yes, you are covered. Those outside of the state go toward that 10.
Oh.
So, yeah, an interesting thing. There's a great, CDLE's done, and I'm not just saying this because I've seen Ms. Marshall speak so many times, but they have a great slide available on their website, which has like the entire country, and then it's got the corporation in Colorado and employees spread all throughout, and then they show you how to count those. Then they've got the corporation outside of Colorado, but then the employees in Colorado. But the key is if they're on your payroll, got something you want to admit, if they're on your payroll on the system, even if they're outside of Colorado, they count toward the 10, but you don't necessarily you don't pay their premiums. Because those, for example, in Utah, don't get to take Colorado FAMLI. If they are truly Utah employees, don't come back to Colorado, have limited interaction with Colorado. There's a whole bunch on that that I'm not going to go into, but if you've got counting questions, make sure you reach out, just send me a quick question. I've got a ton of slides on the counting, but the key is it's not just those Colorado employees who count, though it's only those Colorado employees who will get the leave and you'll have to take premiums from.
Okay, so we've seen this, or I've seen this actually a couple of times. Are H2As counted as they are for FAMLI, I think is what they're trying to say, for FAMLI, or are they not counted because they're not counted for UITR?
That's it. I have always looked at that in terms of they're on the payroll, they come through. Independent contractors would not be because they're not on the payroll. So I would tend to count them, but I don't know if I've seen anything official on that yet.
Interesting.
So I'm always looking to being a little more conservative of how I count. Just because it's better to count them as in because there's much more liability for counting them out. And as you can see, this is one of the slides that discusses the breakdown, the weekly deduction for someone who's earning $1,500 a week, about $70,000 a year, give or take. I'm an attorney, so don't hold me to that math. Is about $6.75 a weekly deduction. So it's not a huge number that we're each going to contribute for our employees. You can see that the numbers, the percentage of the weekly wage tends to go down, or not tends to, does go down based upon what you make. Additionally, there is a cap on this, which is set by Social Security or something. Well, I'm not a tax attorney. So there is an amount, I think it's around 160 now, that once the employee reaches there, the same number that I'm sure you all know if you process those. that's where the premiums stop being withdrawn. The interesting thing I just saw recently, I was trying to find it for this talk, couldn't find it again, but California has done a study on who's requesting the leave. And the interesting thing was that the group that's requesting it the most were the employees in California, mind you, so wage scales a little differently, but the most were those earning 80 to 120,000. Those over 120,000 requested the least, but those requesting it the most are 80 to 120. There's I've heard a lot of questions about lower income workers will request it more. California study actually showed that group is third in terms of requesting and taking advantage of the leave. Perhaps that's because the lower income, when you have a lower income, maybe even the small percentage of weekly wage is something that may not be real workable. So there was no analysis of it, it was just those were the numbers.
Oh, that does surprise me.
I was surprised with that number.
I remember a chat, I think it was the WCHRA presentation from maybe a year and a, was it just?
When everybody was yelling at Ms. Marshall?
Yes.
Yes, that
Yeah.
was in last April.
Okay, and I think.
They weren't yelling, but.
Right, there was a lot of questions though. But didn't she say like 3% of state employees, or of the state's employees were the ones who were using it? So it's not like they were expecting it to be a much larger amount of employees wanting to reach in and use FAMLI, but
Yeah, and
about 3%.
those are interesting numbers because we're seeing different information come out. Though, as I understand, and this was back when this was a legislative attempt, not a electorate attempt, that they were estimating that these numbers all worked out if only 3 to 5% of employees in the state used it.
Okay.
So now the concern is, recent numbers I've seen from Rhode Island have their numbers, which has a similar program, have their numbers at 8 to 10%. So the 3%, I'm not sure where that's from. Somebody wants to get admitted. I'm not sure where the 3% from. I think this will be a fascinating determination over the next couple of years as to how many people use it, because a lot of people say, well, I don't think it'll be much different than our short-term disability insurance. And I always say, yeah, the difference is most employees don't pay for short-term disability, whereas here, they're contributing. Will employees feel more of an interest and a drive to use a leave they're paying for? So it may bump up what they're using for short-term disability. And I would not do any type of analysis in terms of those saying, well, only X amount of numbers use our FMLA under federal law. That's a comparison of apples and oranges. That's an unpaid leave versus a paid leave. I don't think we can take the numbers from FMLA to mean much, so.
Yeah. We do have some more questions about counting employees.
It's everyone's favorite question. How do we know? How do we count?
Yep. So do employees who have left employment with us but worked 20 or more weeks in the preceding calendar year get counted? Terminated employees. If
they're not on your payroll, I mean, you're doing that once a quarter, you got it coming up to determine if you're 10. If you're not, if you go back, where's my number, man? There it is. So it's supposed to be current employees on your list. So when you make that count, you're looking at the current employees on the list. Now, if you go through, that's an interesting question of terminated, but I wouldn't, terminated employees would not count on your list.
Because it's based on the look-back period, so it's,
you're
looking at the year preceding so if
they're off the list, but you're counting only once a year to determine if you have 10 or more employees. Oh, I see what now I get what they're asking. Sorry, that question wasn't sinking in. I'm cut off caffeine, so apologies. So what you're doing is when you do that employer count, what you're going to do is you're going to look back to see whether or not you had 10 or more employees who worked 20 or more work weeks in all of 22. So yes, now I understand the question. So yes, when you make that count, if, I always pick on Bob, if Bob left in July, or August, had worked 20 or more work weeks, Bob's a 1, because he's one of the 10 or more employees who work 20 or more work weeks.
Mhm.
Try that question did not sink in.
Yeah. And one more question on H2A. So if you count H2As for family, do you withhold the premium for them?
I would think you'd have to.
Mhm.
The big rules that just came out are the private plans, and I'm not gonna go into a lot of information on this, because I don't know a lot of people who are using it and are thinking of using it. And in fact, a number of organizations who I work with who, once they saw the private rules, went from, yes, we're really excited to doing it, to no, we're not gonna do it at all, in like a blink of an eye. But for those who are thinking of doing it, the new rules are just out. Keep in mind that all private employers, their premiums are going to start January 1, 2023. If you don't get approved before that time, you're in making contributions. You will be able to get those contributions back, but you're making contributions because you don't have it approved. So don't be holding off like, no, we were gonna go to a private plan or a self-plan. Don't forget that there's still that obligation to make the payments as necessary, as it identifies here. The private plans, as I always say, they've gotta walk like a duck, they gotta look like a duck, they gotta quack like a duck. It's gotta do everything that the state's plans do. I thought it was interesting, just one more second before a question. It was interesting, a talk I saw with the CDLE over at the Colorado Society for Human Resource Management in, where were we? I forget where we were, somewhere near Vail. And they were asked, well, why use you instead of a private plan? It would seem like we should all go to private plans. And their answer was basically, this is all we're gonna be doing 24 hours a day, 7 days a week, 365 days a year. Wouldn't you rather go through us than who does it all the time, than a private self-insurance company or something along those lines, who just does it occasionally?
Mhm.
The other thing is, there may be a little, depending on your private plan coverage, you gotta keep track of who are they putting that responsibility on, are there indemnity clauses, or those kinds of things. So make sure you're looking at that. It may, though, give you an opportunity, using private plans, to give increased benefits. Like, for example, if we go way back here, man, if we go back here and you see, well, you can only get that percentage of weekly wage. Now, that can be supplemented if the employee requests with HFWA or PTO or something like that, but perhaps a private plan gives more for the same cost. So that may be something you want to look into, but I know in working with one organization, they made the statement, we're basically going to have to hire someone just to administer family. That will be their sole job. So that seemed like a lot. Yes, question?
So does the opt-out happen once, or do you have to apply for opt-out every year?
For a government, I think it's like 3 or 7.
Well, I guess if you're providing a private plan,
Oh.
do you have to apply and submit your application?
How often do you have to do that? Let me think on that.
Okay.
I'll come back to that one.
And have you heard how much, because you have to submit payment when you also submit that application?
To the private plan or to?
For the private
state?
plan. For the private, not to the private plan, but if you go with a private plan and you're filling out that application for family to opt out of the state program.
Send in your administrative fee to the state.
Have you heard what that's going to be?
I have not heard what that administrative fee for the state is.
Okay, I heard that it was $500 for the application fee.
Could be.
Yeah, but I haven't confirmed that yet. I
Yeah.
just thought that was interesting.
Okay, what else? How are we doing on time? Good as always. If you're going to do a private plan, can you just admit that person so I can?
Yeah, I got it.
Okay, I just want to be able to see. There you go. If you're going to do that, you want to make sure you're advising of employees of all those rights right there, the proposed notices. In fact, and this is where I have a slight disagreement with the CDLE. It's not the only place, but it's one of the places. They will frequently say, employers need to develop handbook policies, employers need to start putting in leave provisions. Whew. I don't know if I would start amending your employee handbook right now. They're changing things so frequently. The regulations come out, they'll have a proposal period, they'll have a hearing, and next thing you know, they get changed. and then they get changed again because other people come in. So, it is so important in the slide later on. If you go online, CDLE has a paycheck stuffer, they have a poster, send those out with the paychecks, send the poster out. But I don't know, I think we're a little early on how the leave is going to work in 2024, just because I don't think they've got that figured out as well.
Yeah, those are questions that you could bring on Friday when we were doing the
Yeah,
webinar.
well, Tracy and I different on that. She
Okay.
says, put it in your handbook, and more of mine has been, get the information out to employees more than get it in your handbook, because I know how difficult, those can be. If you're going to make changes to your plan, you have to notify the division 14 days before any change. If you're going to voluntarily terminate, you have to tell them, no more than 30 days before the termination. So just some information here, if you go with a private plan, something that just started happening. Proposed private plan application process, again, this is just coming out. This is only about 10 days ago that the state released this regulation. You're gonna apply online. They said coming in 2023, I think they're gonna be, think they may be a little sooner, but don't wanna put pressure on them. You're gonna need to give your basic employer information, contact person, self-insurance, application, require a surety bond. One of the things I get questioned all the time, like, well, what happens if in the first year my private plan runs out, or my self-insured plan runs out in particular? Like, I'm gonna handle this all by myself. And then 3 employees of your 12 suddenly request leave. That's the purpose of the surety bond, to make sure you're gonna have the ability to pay those off if an employee, if too many employees request. Application form to be used by the employee, copy of the posted notices, all this has to be submitted as part of the private plan application process. I thought that these are a couple of interesting questions that have come up on private plan. What happens if it's approved and then I get my premiums refunded? Am I going to have to track down those employees who left, who contributed to this private plan? Yes. They must issue, or those who are there, and you must try to track down those employees that way. I think we've covered all those. Does a private plan have to be set up by an insurance company, or do you have to manage it in-house? You can work with private insurance companies, or you can manage it on your own. You're my official hero if you manage it on your own. But if you do, you will of course be considered the self-insured private plan, and those who need to post a surety bond. You always look over at me when you have a question.
It's a little bit off topic. It's still family, but how do owners, like business owners, need to be treated as far as in the employee count and in the payment of premiums?
They're in, particularly those who, for example, at my law firm, I'm an employee. I own the firm, I'm the only owner, and I'm also an employee. And so they would have to make contributions on behalf of me, because I'm an employee of the organization. So if you're strictly a partnership arrangement, that can be a little differently, because you're not technically an employee if you're only getting paid profits. But any kind of W-2 wages that are being pulled out, so being, when you start being treated like an employee, if you're covered by workers' comp, if you have health insurance as an employee, or however it is, the more you look like an employee, the more that's going to be counted. So the owners would need contributions from that.
So kind of like the HFWA workers, if
Yeah.
they're on payroll.
They're on the payroll.
They're counted as on.
My lien would, and I'd be interested to see what, I have not heard the state ask that question. I would be interested. I have always looked at them as being in. If we submit our private plan approval after January 1, 2023, do we still need to contribute until we get approved? Yes, unless you get approval before April 30th, or the grace period, you have to make those contributions. What's next? Because this is just a little part of the FMLA I wanted to cover. Get notices out, get information out. As I said a few seconds ago, I don't think you need to, they have the employee handbook. Their employee handbook is not the way I write an employee handbook, but that doesn't mean it's wrong. It's just not the way I write an employee handbook. But they have a lot of great information online. Go to the family division, you got the notice poster, you got the paycheck stuffer, you got the pay stub sample, you got the break room poster. All of that is available to get out to your employees in the next 6 weeks. Employees are gonna, if, you know, A, that it's required, and B, it'll be nice, because when that first premium poll gets made, and the first paycheck in 2023, people will notice. Most times, you're not getting, you're not making deductions without someone noticing something.
And I will try to get together those links to send out as a follow-up as well. So
Yep.
just the links that you referred to.
It's under CDLE, employer, and then there's, they have employer tool chest or something like that.
Okay.
That's where it is, and they're all listed, and, it's, there's some, it's the notice they recommend.
Yeah, so they actually have a really well put together website. So if you're looking for information on family, you can Google Colorado Family, and it'll take you,
Oh, yeah.
get to the website, and they have all kinds of employer resources, employee resources. I believe a link to where you can apply if you're gonna register your business yourself for your family ID.
Yeah.
So.
And I say this in talks that the CDLE has attended. I make fun of the CDLE as much as anyone. I've been involved in, not to make fun, where I give them a hard time on, and we definitely have different interpretations with respect to certain things, and we've even had litigations against each other. But I will say this about the family division. They are putting out stuff like crazy. If you ask a question, they will answer it. In fact, they have a link to all their Q&A questions that they did. They have amended their procedures because of those questions. So if you've got questions, if you've got concerns, and you want to maybe see it change or something specific, don't hesitate to reach out.
We did have a question. Sorry.
Sure, hit me.
So you said, print out these documents, put them in with the paychecks when you're handing them out to employees. Well, we have a lot of people who are direct deposit only and are not actually handing out
Is that new?
paychecks. So, will you ever have to prove that you've provided the information to your employees? So is it better to send through an email or track through a portal?
Yeah, I would definitely, if you have an intranet, I'd make them available on that.
Mm-hmm.
If you had a company email, if you've got a company newsletter, I would get this information out in the next 6 weeks. It's not a ton. It's really, quite honestly, it's really, lightly written. It's not onerous. It's not a huge, it's not like reading a Shakespearean play. It's really direct, right to the point. They give the information just to give employees a heads up as to why this money is getting pulled.
Mm-hmm.
A lot of questions get asked like, what if I don't want to contribute? And then basically the Department of Labor is clear, you're still going to. So for that reason, there's some good information there in their paycheck stuffers.
Have you seen anything about 501c3s or religious organizations, if they're able to exclude themselves?
I have not seen that. I don't know if
I've researched it a little bit and I haven't found a definitive.
Yeah, I have not seen.
I
have not seen that either. I would not. I'm going to think on that one. Update. You got to give me the hard questions ahead of time.
I'm sorry.
It's okay. I'm sorry. These are the steps. So determine if you're covered. Determine how many employees. You can go on the FMLA calculator. Consider your plan options. Are you going to use private plans, which of course, as they say here, are not perhaps available because the rules just came out? Certainly something you can start having conversations out. We've already talked. I don't recommend updating the HR manual unless you do something in your manual about withdrawals from paychecks. Then I would identify that. But I wouldn't start getting into how that whole leave provision is going to work, because that's all for next year. Then you need to register. Make sure you register before January 1st, and then just be ready to collect premiums. Oh, look, I have actually the program notices in here. I thought I had identified them. here's the information, the program notices, it didn't all fit on one page, and then here's your helpful little paycheck stuffer that the department came up with. So I definitely encourage getting this information out. Okay, let's go over the last couple of topics I want to make sure we hit on. In addition to the wage issue, this is a big change in the reading of the independent contractor rules. The Department of Labor just issued new rules on how independent contractors are going to work. What's particularly interesting for Colorado employers, don't forget, we're kind of stuck with the one that's most difficult, or the one that makes it the easiest to classify the individual worker as an employee. So when you see the Department of Labor, when you see the IRS, when you see various organizations coming up with these new rules, and we've got our Colorado rules, well, if it's easier to classify someone using the DOL rules, that's the way they can go. So don't forget, you've got to keep track of all of them. They really, the Department of Labor rules, I think, are really pushing the employee. They like employees. So Colorado's got our 10 factors, the IRS has their 20 factors, the DOL has got theirs gleaned down to 6, so they're getting less factors. But they will track a little bit. Colorado's, you see here, opportunity for profit or loss, depending on managerial skill, which is a little different than the way it's cited in Colorado. So if you have independent contractors, if you're working with individuals who you're not taking deductions from, not taking wages from, I often get, I'm sure you guys do too, man, and I get the question, well, contract employee, and I always joke, well, that's kind of like jumbo shrimp. Are they a contract, are they an employee with a contract, or are they an independent contractor? If they're an employee with a contract, then they're an employee. That's easy. If they're an independent contractor, make sure you're looking at each of these new factors. Is there an investment by the worker? How permanent is that relationship? Are they working pretty much with just you, or are they working for others? We, for example, obviously, as a law firm, we work with a lot of different organizations. We counsel them on a lot of different HR issues, employee handbooks, those kind of things. That's what we do for a large number of organizations. But the more, if we worked with just one group, if we just with just auto paychecks or just XYZ, that's going to perhaps make us look like more of an employee than a independent contractor. How much control? How much are you requiring the employee to follow up documents, submit certain things at certain times? That can be so critical for this determination. How integral? This is frankly the Uber factor. Uber for years has tried to, or has classified their drivers as independent contractors, but the Department of Labor, in response to the gig economy, has said, look, if you're hiring a driver for your driving business, it's going to be really hard for you to make that claim that they're an independent contractor, because without this worker, you probably can't perform the job. So with law firms, it's, I have a much easier time hiring an accountant as an independent contractor than I do as an attorney as an independent contractor. So if it's necessarily critical to your business, that's going to look like an employee. So something to keep in mind.
So we did have a question, can an employee work for you and then later in the day contract for you? So like be a W-2 employee in the morning and then maybe be a contract cleaner for your office.
There's no prohibition to that in the law, the way the law reads. Like, for example, everyone's independent contractor. There's no chance anyone could claim, or I could claim I'm an employee of somebody. So, but if I come here on the weekends and you guys employ me as a office cleaner, certainly I can be an independent contractor of your organization and I can be an employee of your organization. What you want to make sure of, though, is because employee is the default. Employee is the easy one, employee, there's no concern. If you're going to classify someone as an independent contractor, they better truly be an independent contractor. To be registered with the state, they have to have their own bank account, they should have their own corporate name, they should not have a lot of control in those duties. You treat them differently as an employee than you do an independent contractor. I had one organization that I worked with years ago that was trying to save on overtime and withholdings, so, yeah, your eyes are already lighting up. So what they would do is in the morning, like you said, they put the person as an employee, but in the afternoon, that individual did the exact same thing, sat at the exact same desk, performed the exact same duties as an independent contractor. That's gonna be a problem. There's no prohibition that you can't be both. You shouldn't be doing anything even remotely associated with the other role, though. That's gonna be a much better argument.
So some independent contractors are registered, but they still use their social security number even when they're in 1099. Would you advise against that, that when they're an employee, they're using their social, and when they're an independent contractor, they have a different?
That would be better. Now, Colorado has a law, one of the few states that do, that allows sole proprietors the ability to use their name as their business name. So I can have Michael Santo without having to register as that, because that's Michael Santo. That is an argument. I was at the Supreme Court. We made that as one of the arguments at the Supreme Court level on the independent contractor. We said, look, the worker in question here, he has the right to use his name as his business name. The court didn't address it, but I thought it was a really good argument. Okay, that's the independent contractor. So if you have those, they say 6, but there's really 7. And that they added like everything else that's relevant, and we're not gonna go into that situation. So you may have seen, what was it, man, in about, I don't know, a week ago, that there was an election. And it's not going to address much with the federal issue, because I don't think the federal, whatever, we're gonna leave federal off to the side. State, there was talk that many expected the Senate to flip in Colorado, and the Republicans to regain control of that. That did not happen in Colorado, at least last time I checked. I didn't see anything that had it close. So that means the Democrats will keep control of all 3 branches, Senate, House, and governor. Not gonna be political, but this is just kind of the way it seems to work out. When we have the Democrats in control of all 3 offices, we as a state tend to see more employment bills. It seems to work out that way. What does that mean? Well, one of the big bills that came up in 2020 and 2019 is this POWER, which is a bill that is going to completely flip around discrimination, harassment law in Colorado, retaliation law as well. For example, we will apply discrimination law to contractors who are not employees. So I could sue Auto Paychecks as an independent contractor for violation of Colorado discrimination law. That may be a change, not that I would. Although John can be rather mean sometimes, but that's beside the point. One of the defenses in employment law, if you have a discrimination or particularly a harassment claim, is that, hey, we've got a policy. But Colorado would limit that policy to only if you could show documented success, and that no employee complained about harassment within the last 6 years. So that would be a change in the law. This is just something to keep in mind moving forward. One incident would be enough to support a harassment claim. It wouldn't have to establish that it's severe or pervasive. And there's just a whole bunch of other things. The hostile work environment is anything that undermines a person's sense of well-being. I'm not sure I've been through many written reprimand discussions or performance discussions where a person didn't feel their sense of well-being was somewhat undermined. But this would change the law. So again, I had an old friend who used to tell me, with respect to being involved politically. Either you get into politics or you get involved in politics or you get out of business. This will be the year in particular. 2020, obviously, we were focused on a few more things like COVID, but 2022, as that seems to have calmed a little bit, definitely going to be more of an issue with those bills. So keep an eye on the federal government with respect to its changes in the wage laws, and then the next 6 months in Colorado, starting January through May, is going to be very interesting for employment law changes.
Do you remember you talking about power a couple of years ago?
Yes.
It just got washed by the wayside.
Yeah, you were like, and it's gone. And then last year they tried it again, but it was a really slimmed down version. It just changed a couple of things with statute of limitations and those kind of things. So there's a couple of big changes in Colorado, and I want to make sure we go over the one, which is actually later, but it's really, I want to make sure I get to it, is if you haven't gotten your workers' compensation poster up yet, which is literally as big as I am, not literally, it's getting close, make sure you get the new workers' compensation poster up. It's supposed to be 40 by 27. If you've got Spanish-speaking employees, make sure you post it in Spanish as well. It's very large. Yeah, but it's literally the biggest poster for one law. The other thing, and it's in this materials as well, EEOC just came out with a new poster, OFCCP just came out with a new poster. Many of you are not probably covered by the OFCCP, which just concerns affirmative actions and those kind of things, but make sure you're getting up your new workers' comp poster. You're only a couple months late on that, so no time like the present. And the EEOC poster just came out. They're requesting that employers post it when it's reasonable. I wouldn't push that too much. I would focus getting that up as soon as possible. So those are some big changes. But I think the really big change in Colorado law is just simply the change to the non-compete, which basically starting in mid-August 2020 has made it really difficult it can happen, but it's made it difficult for organizations to get a non-compete agreement over their employees unless it goes to trade secrets. If it goes to trade secrets, that's a different story. Then you can get a non-compete, then you can get a non-solicitation. If you want to get those, make sure you're working with counsel on that issue because it is such a tricky issue for non-competes, non-solicitations. They really restricted organizations' ability to get those, but they expanded our opportunities for a couple of things as organizations. So here's some good news, which is, one, it's much easier now to get money back from an employee who you send to education and training. The old law said you can only get that back during the first 2 years of employment. This law changed it to say you can get it at any time, but the amount you can get back has to decrease proportionally over the next 2 years. That's a big change for organizations because a lot of times you don't send new employees to big, expensive training. You do it after they've been with you a long time and you then take on the big, expensive training. But you can now get that back after 2 years, which was restricted to before, but you just have to proportionately decrease it each month. Big change to get that money back from employees. The other thing that is a big change is they clarified in the law that you can have a confidentiality provision as long as it doesn't go to something that's general, the worker already knew, those kind of things. So if you've got, don't focus as much on trade secrets, as I like to say. Trade secrets, not many of us have. There's a couple companies in the area that have trade secrets. For example, if I take Auto Paychecks, take Bechtel Santo, our trade secret is we just do it better than everybody else, right? Isn't that our trade secret?
I think so.
But there's no, for payroll processing, it's not a secret formula for payroll processing. It is what it is. It's those relationships and just doing it better. That may not be confidential information, and it's certainly not a trade secret, but those confidential information that you want to protect, you really can protect now. So I really encourage organizations to start coming up with some confidentiality agreements with their employees to protect that information. The rest of it, we've already gone over. You can get repayment of scholarship, which works a lot like training, the sale of the business. Question?
Are recipes trade secrets?
Well, I can't cook, so they could be Greek to me. But yeah, I think you could make an argument that, like the formula for Coca-Cola, if we remember I always like referencing Seinfeld, but if you remember the Soup Nazi episode, there was the soup recipes that only he had access to. I think there could be an argument that that's a trade secret.
Mm-hmm.
Now, you don't want to post them on the in the kitchen so everybody can see them as they're walking by. That may be a concern. But if you keep them confidential and there's something you came up with, and it's not something, I certainly think there's an argument that recipes could. I mean, for example, Enstrom's Toffee probably considers, just to pick down the street,
Sure.
They probably consider their how they make their toffee to be a trade secret.
Mm-hmm.
Because there's something in there that makes that phenomenal. So, yeah, you could definitely get a trade secret there. This is all the covenant stuff. If you're going to do anything, please, please, please do not put it in an employee handbook. It is not a policy, it is an agreement. So make sure you're taking it out of the employee handbook. So critical, confidential information. If you're going to have a non-compete, if you're going to have a non-solicitation, if you're going to have the training payback agreement, make sure you take that out of the employee handbook. I see them in handbooks all the time, and I just don't think they're a good place because, of course, your handbook says this is not an agreement. Okay, a lot of stuff we want to cover. How am I doing?
A couple minutes left.
Okay, good, yay. My watch is. Let's see. Oh, and I always bring this up. Just be really careful with non-compete agreements and non-solicitations. It turns out that there's now an argument that requiring an employee to enter into a non-compete agreement that isn't going to work could potentially be a Class 2 misdemeanor, actually a criminal violation. So you don't want to take that approach of like, well, I know this isn't going to work. The employee doesn't know. So if they don't know, well, it may work anyways. That actually could be a criminal penalty. I don't see a lot of criminal, prosecutions coming up because of it, but it is provided for in the law. And so I'd be very careful about that. This is what we talked a little bit earlier. Make sure you get the workers' comp. It is a dramatic change in the law. It's gone from 4 days to 10 days to report. It's also changed occupational diseases. There's just a whole bunch of things out there, and you want to make sure you get the new, because it became effective September of 22.
And for those clients of Auto Paychecks that have the labor law subscription service, you don't have to worry about that. The new labor posters, anytime that updates throughout the year, a new labor poster is just going to be mailed to you. So if you don't have that and you need it, contact me and let me know. Yeah,
contact anyone. It's available online, but definitely get a hold because where are you guys finding paper that's 40 by 27, by the way?
We don't print it. We partner with a labor poster service.
Okay.
They keep track of all of that for us.
I'm always impressed. I want to know who came up with the 40 by 27 side. We've talked about this. A couple quick things on HFWA, Colorado Health and Families, everybody's favorite topic. We are still under a public health emergency. The Department of Health re-upped that declaration in mid-October. That means we're under it through at least February 2023. Will they re-up it in January? I won a lot of lunch bets on October that they were going to re-up it. Less thinking they're going to do that in January, but we will see. A new strain has just started. Final question, do we have to provide public health for monkeypox? No. Yes, the federal government did come out and declare it to be a public health emergency, but there are other requirements that were not met within the law. So monkeypox is not a public health emergency. You do not need to give another 80 hours based on.
Thank you.
You're welcome.
A presentation is not complete without talking about HFWA.
Oh, my God.
Profession.
HFWA I think the moment public health emergency goes away, HFWA gets a lot easier, but in the interim, public health emergency is the whoops trip of all HFWA questions.
And for them to come out at the same time and everybody having to absorb both of those.
Yeah, particularly, I thought it was, I mean, now we're going back a little bit, but particularly for small employers to be exempted from coverage if you were a small employer in 2021 with respect to sick leave, not starting until 2022, but yet still having to apply to give public health emergency leave in 2021 was one of the more unusual aspects of it. I was just doing a talk recently with Representative Soper in the room, and I made a statement of, like, this is why I think they passed it in the legislature, and this is that. And I said, I'd be anxious to hear Representative Soper's opinion as to that's why they did it. And he said, yeah, I wasn't thinking that at all. And I said, what were you thinking? He's like, I didn't even realize it worked like that. And so sometimes those things come in.
Well, thank you so much for
You're
your
welcome.
time today and all of the questions that you answered and all of the time you took to share your wisdom and advice.
You'll get the outlines out?
I will send out
Sounds
the
great.
links, I'll send out the slide, I'll send out the recording. We had some questions earlier about family, just specific to auto paychecks. Auto paychecks will be collecting both the employer and the employee contributions starting on any wages paid on or after January of 2023. And we also will complete the quarterly remittance of those contributions and the reporting. So that's not something that auto paychecks clients are going to have to start doing. We will take care of that for you. I know we have.
What a deal.
Yeah, so that's part of the payroll package. So if you have any questions and follow-up, you can email them to me. You can also reach out directly.
There's my email right there,
Michael.
admin@bechtelsanto.com. They will get the question over to me if you have any questions.
Yes, so thank you all for joining and for asking your questions. And for those of you who want some further guidance on family, hopefully you can join us on Friday as well. Thank you.